So you might, this is not, this is,
Yes.
we're not, this is, do you understand?
I said yes.
Okay, that there's nothing else that's gonna come out of your mouth. Because I'm telling you right now, if I find out that you've had any contact with her, I am sending you to prison. Do you understand me? That's the only way that I'm gonna give her peace of mind. It's either you understand or you do not. You will follow my orders or you will not. That's as simple as that. All I want to hear is, yes, Your Honor, I will follow your orders.
Yes, Your Honor, I will follow your orders. There's no doubt.
You'll be released on electronically monitored house arrest, and you will remain on house arrest at the PO's discretion, on monitor at the PO's discretion. Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison on this upon your release, the authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. The court does find that you have the ability to pay the costs of prosecution. If you don't pay those, the court can order you to do community service of up to 40 hours per month until you're paid in full, or an appropriate arrangement is made for payment of those costs. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
No, sir, thank you.
Mr. Perry?
Judge, very briefly. Rodney's very literal. He's worried that there's going to be a divorce hearing and he's not going to be allowed to go because of the no contact order. I will explain to him it doesn't include court proceedings.
As long as you're in this building with your attorney, that would not be a violation. But you will, any conversations with her will be through your attorney, and your divorce attorney, not Mr. Perry, obviously, because he doesn't do divorces, right? Okay.
Correct.
Second question.
Second issue, again, he's having another flare-up on his foot and his toes. He's going to see his podiatrist. There may very well be surgeries that require him to take medications. I just want to bring that to the court's attention.
I was aware of that. The court actually had granted a furlough on
I
this.
understand, yes.
It was Lebanon Municipal that denied it, so.
You can adjust with the monitor for
Yeah.
any type of medical procedure.
Just talk with your, communication with your probation officer is important. If you have contact from Ms. Long, you do not respond to it, you just alert your probation officer. You need to keep them informed. The monitor is as much for her protection as it is for yours. So if she says that you've been around her, we're gonna be able to verify exactly where you are when. So, anything else, Mr. Perry?
No, thank you, Judge.
All right, that's all. Keely? Your client did not show up. Number 25CR42978, the State of Ohio versus Rodney Long. Mr. Long is before the court with his counsel, Mr. Grom, and Ms. Tranter on behalf of the State of Ohio. We're here on a preliminary probation violation hearing. Officer, could you read the allegations, please?
The allegations are the defendant violated special condition number 15E, and on March 3rd, 2026, during a home visit, was found to be in violation of the no contact order, in this case by having direct contact with the victim.
All right, Mr. Grauman, we've discussed this already in chambers. What's your pleasure?
He's prepared to enter a admission, Your Honor, and resolve this matter.
All right, Mr. Long, you understand you're entitled to have a hearing on this allegation?
Correct.
You wish to waive that hearing and admit to the violation?
Correct.
All right, the court's going to find that you have violated the terms of your community control. Mr. Long, I don't is Mrs. Long present?
She is not, Your Honor. My understanding is she could not get off work to come today.
All right, Mr. Long, I received a letter from you and from Mrs. Long. I was very clear with you at the time that I sentenced you, just back in December, just a few months ago, that you were to have no contact with her, and that if you did, that I was going to send you to prison. Do you want me to replay? I can actually pull up the video if you'd like, and I can replay that where I said that.
No, I understand.
Here's where this defendant makes a massive mistake. Instead of taking responsibility, he tries to justify violating a court order by turning it into an emotional speech about love and religion. But judges do not care how romantic your excuse sounds when you knowingly break a direct court order, especially in a domestic violence case. The entire purpose of a no-contact order is victim protection, and once a defendant starts ignoring those restrictions, judges often view it as blatant disrespect for the court's authority. Let me ask you this. If someone was warned repeatedly and still broke the order anyway, should the judge have sent him straight to prison right here?
What seems to be the problem? What about my order do you think that you can just ignore?
Your Honor, you're asking me to do the hardest thing in my life, is to give up love for someone. Love is the biggest commandment in the Bible. So love God above all things and then love your neighbor. Your Honor.
Mr. Long, I'm going to cut you off because I'm sure it says something in the Bible about violence and hitting women. So you were convicted. Listen, you were convicted of felony domestic violence.
I didn't hit.
Mr. Long, I'm not going to argue with you. You were convicted of felony domestic violence. This is the victim. I ordered you not to have contact with her, and you're violating my order, and I told you specifically that if you violated this order, I was going to send you to prison. Tell me why, and do not quote scripture to me, sir. Tell me why I should not just send you to prison right now.
Because she came over and she's gotten help with her mental illness. We love each other. I can't stop that.
I didn't know if that was anybody related to Barbara.
I'm sorry?
I didn't know if that was anybody related to
I don't think so.
the case.
Mr. Grauman?
Your Honor, I understand my client's position. I think ultimately he knows, he does know in our talks, he knows he cannot be doing this, and they just have to adjust and go about the proper channels. For what it's worth, what that letter's worth, I mean, it does look like she wants the no contact order dropped. I realize the court's not going to do anything on that today.
And I hope you realize, Mr. Grauman, I can't do anything based upon a letter.
Totally
There
understand.
has to be a record made. That person has to appear in person so that they understand, so I can make an assessment that they understand that there's not any types of threats or coercion being made for her to write a letter. I will never accept a letter to drop a no contact or protection order. It's not going to happen.
I totally understand. I'm not asking for that, Your Honor. I guess my point being, she seems supportive of him. There was no allegations of violence in this current violation of the no contact order. He's owning up to what he did. Your Honor, he's 64. He is semi-retired, owns his own company. The court's aware of the health issues he's gone through. The court furloughed him before I even got involved. He's lost toes, has a significant infection. So we'd ask the court to not impose prison time, ideally give him a period of time on GPS and restore him to community control, Your Honor.
Is there a request for a GPS monitor?
There is not, Your Honor.
I would just think that would probably, I think the infection's in his leg or foot or something, right?
It is, but I'm not sure of any other way to ask for some kind of home confinement without that.
Mr. Long, if you and your ex-wife, wife, want to get back together, that's between the two of you, but there's a proper way to do that. And certainly simply by ignoring my orders is not the way to do that.
What's the proper way?
I'll talk to you about that.
Okay.
So either you follow my orders or you don't, and I know you have some medical issues. The court has been responsive to the request for your medical treatment. But I will tell you that you get excellent medical treatment when in prison. So if that's where you want this to go, just keep violating my orders. So this time I will continue you on community control. You've served 43 days so far on this offense, or on this case so far. I am going to continue the no contact order, Mr. Long. I cannot remove it unless she appears personally in my courtroom on the record, and I can question her about whether this is what she wants to do. A letter from her is insufficient. So again, I'm going to do this. So you are ordered to complete the batterer's intervention program and all the previous orders of the court, which included the thinking for a change course. Now, This is your last chance, and again, you're not gonna come in here the next time and tell me, I'm in love. It doesn't work, sir. If you wanna do that, talk to your attorney. You're paying good money for Mr. Grauman, who does an excellent job for you. He's literally kept you from going to prison today. So if you want to, there's a way to do it, a legal way to do it. So do it that way rather than just ignoring me. Are we clear on that?
Yes, Honor.
All right, that's all. PR 42978, the State of Ohio versus Rodney Long. Mr. Long is before the court with his counsel, Mr. Grauman, Ms. Tranter, on behalf of the State of Ohio. We're here on two issues. The first is let's do the preliminary probation violation. Officer, could you read that allegation, please?
Yes, Your Honor. Under Special Condition 15E, on March the 31st of 2026, during a home visit, the defendant was found to be in violation of the no contact order in this case by having direct electronic communication with the victim.
All right, Mr. Grauman, does your client wish to have a hearing on this allegation?
No, Judge, one or admission.
All right. The second issue. All right, Ms. Long, is that your name?
Yes.
You step forward, please.
Sitting right here in front of this table, so the microphone picks up. If you can please state your name for the court reporter.
My name's Gwendolyn Long.
Okay, what do you want me to know?
I'm here today to ask if you'll drop the no contact order. We've had 6 months or longer to realize where we messed up. And I do have my own place, and I was wanting to try to work things out.
You requested the no contact order. Do you recall that?
Yes, I do.
What's changed?
I've had 6 months to realize that I'm still in love with him, and we both messed up, and willing to seek marriage counseling, and just, date and get to know one another. Instead, we jumped into the marriage too fast, and I'd appreciate it if you would drop it so we can work things out.
Have you ever been the victim of domestic violence at the hands of Mr. Long other than this occasion?
I can't recall.
You can't recall.
I believe so, Judge.
Mr. Long was convicted of domestic violence in Levy Municipal on February 12th of 2025. He was convicted of domestic violence in September of 2024. So he has at least 2 prior convictions for domestic violence.
Your Honor, I'm not afraid of him.
You told me before that you were.
At that time I was, but I've had time to think about things, and I really want to work my marriage out, sir.
All right. You understand that once this order is dropped, then that's the extent of your protection at this point in time. I understand it's just a piece of paper, but you'd be losing all protection as far as him having contact with you. You understand that?
I know that.
This is what you want me to do?
Yes.
All right. The court's going to dismiss the no contact order at this time. Mr. Long, regardless of that, I ordered you, and I told you I was going to send you to prison, didn't I? Last time you were in front of me, you just ignored that.
No, we didn't, sir.
Sir, you are so full of crap right now because we sat here in this courtroom, what was it, less than 30 days ago? You quoting scripture to me about love and this and that, and then I told you.
This is the moment the judge realizes the defendant learned absolutely nothing. After being given a second chance, after being warned again, after being told prison was next, he violated the order again. And notice what infuriates the judge most here. It's not just the violation, it's the refusal to be honest and admit responsibility immediately. Courts often punish dishonesty and excuses more harshly than the original mistake because it shows the defendant still doesn't respect the process. The judge is basically saying, stop manipulating the situation and own what you did. At this point, many judges would impose prison without hesitation.
The no contact order, it remains in place, then just a few days later, I find out you're having contact with her. You literally just ignored my order. You want to explain that to me?
We didn't ignore
You think I
it.
was kidding?
No, we didn't ignore you, and we're not trying to.
Mr. Long, you are lying right now because when I order something, I expect my orders to be followed. I ordered you, I told you when you were here last time, Ms. Tranter reminded me this morning that if you violated my order again, I was going to send you to prison. Do you understand what that means? Do you understand what no contact means? I don't want to hear you give me some excuse right now. I want to hear you admit that you violated my order. That's what I want to hear out of your mouth right now. Because I'm tired of your crap.
Yes, we made contact.
All right, thank you. Was that so hard to do?
No, it's not hard to do, but there's also extenuating circumstances that we tried our best to stay apart.
Sir, no. You made it. I made an order.
We made contact.
Thank you. That wasn't that difficult, was it?
Appreciate it.
All right. Despite this violation and under the change in circumstances, the court is going to continue you on community control at this point in time. For this violation, the court's going to order you to serve 30 days in the Warren County Jail. You get credit for the 10 days you've already served in this violation. You have a total of 53 days total. So you're going to serve an additional 20 days for violating my order, but I'm not sending you to prison today. Mr. Long, the no contact order is dismissed. Again, if you don't get some help with regard to your anger issues, whatever your violent tendencies are towards people that you profess to love, then you're going to be back in front of me. And I'm going to tell you right now, if you come back in front of me on an F3 domestic violence, we won't be. It's not going to matter what attorney you hire because you're going to be going to prison. You understand me?
Yes, sir.
All right, that's all.
Your Honor, would the court consider EMHA and
No,
the jail?
he violated my order, Mr. Grom, and he's gonna pay a sanction for violating my order. Moving forward, the no contact order is dropped, but he knowingly violated my order. He's not going to prison today, but he's gonna be sanctioned for violating my order. That's all.